Good morning, everyone, and welcome to the third and final session of our Environmental Rights webinar series. As many of you may know, Community Law and Mediation set up the Centre for Environmental Justice in 2021 to work on bridging the gap between environmentalism and social justice issues. In other words, the protection of both people and planet. And ensuring that everyone has awareness of their environmental rights is a critically important aspect of this. So we especially welcome those joining who might be new to this area, and hopefully greater knowledge of environmental rights or the Aarhus Convention might provide new insights into how social and environmental justice issues can be addressed holistically. Today we are discussing the third pillar of the Aarhus Convention, access to justice. So when do environmental concerns become a matter of injustice, and who gets to go to court? This webinar could hardly be more timely. We are living through a Dáil declared climate and biodiversity emergency while inequality continues to rise in Ireland. Yet the potential financial risks of bringing an environmental case before the courts remains a live concern, alongside attempts to restrict access to justice for environmental NGOs. Strong environmental legislative and policy frameworks at both the EU and national levels aren't providing the results that they should be because they are not always properly implemented. So access to justice is an essential tool to reduce the gap between environmental laws and policies and their implementation. Chief Justice Donald O'Donnell has warned that the law becomes dangerously disconnected from the public it is meant to serve if people do not have adequate access to justice. And Judge Anthony Collins, a judge of the General Court of the European Union, has called for improved access to the courts for environmental activists due to Ireland's astonishing reluctance, in his words, to comply with EU environmental laws, only seeming to pay attention when taken to court. We are really grateful to the Community Foundation for Ireland for funding these talks, and to our excellent guest speakers today, Rose Wall and Dr. Orla Kelleher, for generously sharing their time and their expertise. We will have time for a Q&A at the end, so if you have a question, please do put it into the Q&A box at the bottom of your screen. And if you see a question similar to one that you would like to ask, you can upvote that question with the thumbs up icon, and that will make the question more likely to be addressed. As this is a short event, I'll just introduce our speakers and let them get started. Rose Wall is the CEO of Community Law and Mediation and the Centre for Environmental Justice since 2013. She holds an LLB and an LLM from the University of Dublin Trinity College and is a member of the Law Society Human Rights and Equality Committee, a member of the Board of Directors of the Immigrant Council of Ireland, and a member of the Legal Aid Board Consultative Panel. Dr. Orla Kelleher is an assistant professor at the School of Law and Criminology in Maynooth University. She specialises in climate change, environmental and human rights law, and her current research focuses on environmental rights, climate litigation, climate justice, and just transitions. Orla is also a non-practicing barrister, having been called to the Irish Bar in 2020. So Rose, I'll let you take it away whenever you're ready.
Thanks so much, Doda. I'm just going to share my screen.
Yeah.
Can you see that okay?
Yeah, that's perfect. Thank you.
Perfect. So good morning, everyone. You're very welcome. As Clodagh mentioned, this is the third and final webinar in our Aarhus Convention series. And today we're going to be looking at the third pillar of the convention, which relates to access to justice. But you'll remember that in previous sessions, which are available on our website if you want to rewatch them, we learned about the first pillar, the right of access to environmental information, and the second pillar, the right to public participation in environmental decision-making processes. So for today's talk, I know Orla is going to be talking about some of the really interesting cases at home and abroad which have benefited from provisions in relation to access to justice in environmental matters. But I'm going to discuss really briefly why access to justice in environmental matters is firstly so important. Secondly, what the Aarhus Convention actually provides in relation to access to justice. And thirdly, what some of the barriers and threats to access to justice in environmental matters are in Ireland. So, firstly, why is access to justice in environmental matters important? And I think it's worth just talking about that because there are some threats and barriers to it. So we need to kind of start from the basics as to why it's important that this right is protected. So it is recognised as a right in international environmental law. Principle 10 of the Rio Declaration, as well as the Aarhus Convention, accord a central importance to access to justice in achieving the goal of environmental protection. This has generally meant less cost risk, though notably no legal aid, and more relaxed rules on standing, which I'll talk about later. There's also a moral principle at play here. Climate change and other environmental harms have a greater impact on marginalised communities, and the destruction of the environment has reached such a level that the world of current and future generations is severely compromised. In our Centre for Environmental Justice in CLM, where we provide legal advice and representation, we have provided legal assistance in relation to air and water quality concerns, damage to and potential loss of homes due to flooding, proximity of toxic waste to residential areas, and concerns about negative environmental impacts from proposed developments. We know that despite our laws, many of them quite good, the climate crisis and other environmental issues are disimproving. Emissions are increasing rather than decreasing. According to the EPA, only 20 rivers have pristine conditions compared to 500 in the 1980s, and air pollution contributes to approximately 1,300 premature deaths every year. We also know that important and protected ecosystems are being eroded and biodiversity lost on an unprecedented scale. We know that 71% of landfill sites and waste incinerators in the country are located in areas that are below the national average of deprivation, and that there is unequal access to green space, with more trees than residents in Ballsbridge, with only 10 residents per tree in the North inner city. So the law on its own is not enough. We need to ensure that that law is enforced, that the government, corporate bodies and others are held to account in relation to breaches of environmental and climate obligations. So I'm sure Orla is going to discuss some of the cases, but they might include, for example, challenging a development through the planning system because it is likely to generate significant emissions or adversely affect the environment through pollution or habitat destruction. Or it might include, as with Climate Case Ireland, challenging climate policy itself in court for being vague and lacking in detail. To ensure that the law is enforced, we need to ensure that people and groups know about the law, how it applies to their situation, and have access to the courts and legal assistance if that is necessary. Around the world, a number of strategic climate litigation cases is dramatically on the rise. There was a recent paper written by former Minister and Senior Counsel Alex White, which concluded that the majority of climate cases taken against governments in Europe have led to outcomes resulting in greater climate litigation or regulation. The importance of access to justice in environmental matters has been somewhat recognised at an institutional level. In the last 10 or so years, Ireland has made significant changes to its standing, so who can take cases to court, and cost rules, so what happens at the end of a court case in relation to costs, as a result of its adoption of the Aarhus Convention. Further, the judgments of the Court of Justice of the European Union and communications from the European Commission have consistently made the link between access to justice in environmental matters and environmental protection. I think it's worth noting that traditionally environmental law has been reliant on the European Commission for enforcement, but the Commission has started to withdraw, if you look at its numbers, from enforcement and is outsourcing it to environmental NGOs by systematically promoting access for such groups to national courts. So the second thing I'd like to look at is what the Aarhus Convention actually provides in relation to access to justice. So you'll know from previous sessions that Ireland ratified the Aarhus Convention on the 20th of June 2012. Article 1 of that convention provides that each party to it must guarantee the rights of access to justice in environmental matters. So, for example, that might be through judicial review or a nuisance claim. And Article 3 provides that each party shall take the necessary legislative measures to achieve compatibility with the access to justice provisions in the convention. So Article 9 is where you'll find the access to justice third pillar provisions. And a key cornerstone of it is to ensure that the first two pillars are upheld. So you'll see, for example, that Article 9.1 relates to access to information and ensures that any person who believes that the request for information has been wrongfully refused or inadequately answered should have access to a court or tribunal or independent body established by law to review the procedure. Article 2 relates to the second pillar, public participation, and it ensures that any affected members of the public should be able to review the substantive and procedural legality of any decisions within the scope of Article 6, which relates to public participation in decisions on specific activities. This right is granted to members of the public concerned who have what's called a sufficient interest and what's called an impairment of right. So what constitutes both a sufficient interest and impairment of right is a matter of national law and is usually assessed when an application for judicial review is made. However, that national law has to be construed consistently with the objective of the Aarhus Convention of giving the public concerned wide access to justice. It's important to note that under the convention, environmental NGOs who are active in environmental protection have been recognised as having this sufficient interest and can take cases to court, which is why we see, residents groups, ENGOs like Friends of the Irish Environment and Taoiseach taking cases regularly, whereas in other areas of law, you need to show, for example, that you're personally affected before you can take a case. It's also worth noting that Ireland changed its law as a result of the Aarhus Convention under the Environment Miscellaneous Provisions Act 2011. It had been the case that an applicant had to show substantial interest, but on foot of this act, and because of the public participation requirements of the Aarhus Convention, it was changed from substantial interest to sufficient interest. And it's important to note that because actually there have been recent moves by government to move it back to that former, more restrictive rule. So it's interesting to see that we changed the rules to improve access to justice on foot of the Aarhus Convention, which itself hasn't changed, but we are now looking to kind of unilaterally restrict our own access to justice, which I'll talk about in a moment. Article 9.3 then relates to breaches of environmental law. So maybe this is broader and not in relation to maybe specific developments or activities. And this item ensures that members of the public have access to administrative or judicial procedures to challenge acts and omissions by individuals and authorities which breach national environmental law. Article 9.4 provides that provisions mentioned must be fair, equitable, timely, and not prohibitively expensive. So, for example, what's timely depends on the complexity of the matter and varies between the various pillars. And in relation to procedures not being prohibitively expensive, this wasn't defined in the convention, but it is to ensure that an applicant is not to be put off seeking judicial remedies by virtue of the costs involved. So while costs are certainly still an issue in Ireland, and I'll come back to this later under threats and barriers to access to justice, the situation is a bit easier because of sections 50B of the Planning and Development Act 2000, which relates to planning permissions, and Part 2 of the Environment Miscellaneous Provisions Act 2011, which relates to, for example, breaches of planning conditions likely to cause damage to the environment. So section 50B relates to, you'll see 9.2 there, public participation, whereas the Environment Miscellaneous Provisions Act 2011 really relates to 9.3, so breaches of environmental law. And these legislative provisions essentially implement the not prohibitively expensive rule in Aarhus. So the normal rule in any litigation, which most of you will know, is that costs follow the event. And what that means is the losing party in a case pays not just their own legal costs, so their own solicitor, barrister costs, but also the costs of the winning party. As these costs, particularly in a High Court or Supreme Court action, can be really significant and run into certainly the tens, if not hundreds of thousands, this rule can act as a significant deterrent. However, under section 50B of the Planning and Development Act, special rules apply in cases involving the Environmental Impact Assessment Directive, the Strategic Environmental Assessment Directive, the Industrial Emissions Directives, and the Habitats Directive. So these all relate to kind of developments that might potentially affect the environment. So under these rules, a member of the public, if they lose the legal challenge, will generally only be fixed with their own costs and not the costs of the winning party. So if you lose, you have your own costs to pay, but you might have secured a kind of no win, no fee arrangement with your lawyer, and you won't have to pay the costs of the winning party. But if you win your case, you will most likely be entitled to your costs from the losing party. Either your total costs, but more recently, because of a decision, maybe just part of your costs. So if part of your case related to, for example, the Habitats Directive, but other parts of it didn't relate to those 4 directives I just mentioned, then only those arguments would be covered under these cost rules. So that was kind of a recent decision on that. It is possible to apply to the court either before or during proceedings for determination that cost protection applies, which would give comfort, obviously, to an applicant. And as I said, these special cost rules were to give effect to the obligations of the state to rectify its failure to properly transpose the public participation directives following the decision in Commission versus Ireland. So in that case, the Court of Justice of the European Union found that the pre-existing regime in which the High Court had discretion regarding costs did not comply with the directive as it lacked certainty. The final element of this is Article 9, subsection 5, which provides that appropriate assistance mechanisms must be considered to remove or reduce financial and other barriers to access to justice. And this has been held as not including legal aid. One final thing just worth mentioning under this is that there is an Aarhus Convention Compliance Committee. This committee ensures compliance by the parties of the convention and allows members of the public to communicate concerns directly to a committee of legal experts. The committee cannot make binding decisions, but makes recommendations which are usually followed. Okay, just looking at the final section then on barriers to access to justice in environmental matters in Ireland and threats too. So firstly, in relation to barriers, We had mentioned the special cost rules for certain environmental or planning cases under Section 50B of the Planning and Development Act or the Environmental Miscellaneous Provisions Act. So where these rules clearly apply, the result is much improved access to justice, because lawyers can sometimes take cases for applicants on a no-win, no-fee basis, and applicants can take those cases knowing that their financial exposure, if unsuccessful, is limited. So they won't have to pay the costs of the winning party, and they similarly won't have to pay their own solicitors and barristers' costs if they have this arrangement with them, but they will have to pay maybe small costs around court fees and outlay costs. So not significant in the grand scheme of legal costs. However, it should be said that it's not always possible to find a lawyer to take on a case on a no-win, no-fee basis. And there's always been an element of uncertainty about whether the cost rules apply or apply to the entirety of the case. Also, Ireland has been criticised by the EU Commission on a number of occasions as being the most expensive member state in which to take an environmental claim before the courts. Our civil legal aid, currently under review, does not provide legal aid for companies. So, for example, environmental NGOs, and although this is under appeal to the Supreme Court at the moment. And while individuals are not specifically excluded from legal aid in environmental matters, it's not advertised, so nobody even knows to go and apply to the Legal Aid Board. And the Legal Aid scheme has a number of exclusions and exemptions from legal aid, which might prevent legal aid being granted in environmental matters. So these include, for example, actions relating to an interest or a right in or over land. So anything that involves that cannot qualify for legal aid. Similarly, actions representing a group or actions looking to establish precedents or on a particular point of law, none of those types of cases qualify for legal aid in Ireland. So while environmental cases aren't specifically listed as an exemption, many of the cases won't be included, and the fact that ENGOs are considered a corporate entity and cannot apply for legal aid also excludes quite a number of environmental cases from legal aid. The law is particularly inaccessible for vulnerable or marginalised groups disproportionately impacted by environmental problems, who in a recent report by ourselves in DCU were reported as feeling largely excluded from environmental and planning decision making. Members of the public who have sufficient interest, so remember that sufficient interest and impairment of right, may not know their rights under the Aarhus Convention, or they may not know that they can go to court in relation to acts or omissions which breach environmental law. So I just want to look finally at threats to access to justice. And I think it's fair to say that there's an ongoing tension between Irish policy and law and international law. So Irish policy and law has traditionally pulled towards making it more difficult to challenge environmental decisions in court, whereas international law, the Aarhus Convention and EU law have tried to make it easier to bring such challenges at the national level. And look, you know, you'll see even over the weekend, and it's constantly in the press at the moment, that there is a kind of a narrative in the media and by politicians about a growing industry of legal challenges holding off the building of much needed housing. And these discussions have instigated an overhaul of the planning process by the Attorney General, and part of this review will include the establishment of an environmental and planning court in the first quarter of 2023, along the same lines as the commercial court, which is really just a commercial list of the High Court. As a result of this review, the previous Housing and Planning and Development Bill 2019 has been shelved, and I think it's worth saying a few words about this bill as it illustrates government's thinking on the issue. It's clear from the explanatory notes included in the general scheme that the primary, if not sole purpose of the bill was to reduce and restrict challenges to planning decisions. The bill would have reversed previous efforts of Ireland to comply with the Aarhus Convention, despite the fact that the Convention itself is unchanged. So, for example, it included proposed changes to the special cost rules, which I've mentioned, so that the applicant, if they lost their case, would have to pay €5,000 in costs, or if they were an ENGO or group, would have to pay €10,000 in costs. If they won, their maximum limits. If they won, the maximum they could claim from the other side would be €40,000, which sounds like a lot of money, but when you're sharing that out amongst a legal team, which might include a number of lawyers, 2 or 3 or 4 lawyers, it's not a huge amount and would certainly deter lawyers from taking on no win, no fee cases where they're dependent on a win to kind of pay for the number of other cases. It should be said that as well as those kind of changes to cost rules, the court could vary the amounts, you know, as they saw fit. So that kind of goes against the prohibitively expensive rule that we saw before, which was really to ensure that applicants weren't kind of deterred from taking a court action because they were worried about costs. So these kind of provisions would really have gone against that. The bill also proposed additional requirements on NGOs in terms of the number of members, would require 100 members and length of time in existence. So from 12 months up to 3 years, which really would have stopped, residential groups or grassroots groups which develop it on sometimes on an ad hoc basis, on the basis of what's going on in their locality and their community, from taking legal action. The bill really would have represented a retrograde step in terms of the fulfilment of our obligations under EU law, and would have had a chilling effect of environmental litigation, seriously damaging environmental oversight and democracy in relation to bad and unlawful planning decisions. And changes, for example, that we saw in the summer in relation to the judicial review process were put forward at the 11th hour in July, including a proposal ultimately withdrawn after backlash that would have allowed on board Pleanála to frustrate judicial review proceedings against aspects of this decision by simply changing those aspects mid-proceedings. Now, finally, in relation to the proposed environmental court, we really have very little information on this, except that it's going to be along the commercial court model, so the devil will be on the detail. Any proposed court must be more than a fast-track planning court accessible only to the well-resourced. An environmental court which can truly enforce the environmental rules of our society must have an open door to environmental justice. Environmental courts have been established in lots of other jurisdictions, such as the New South Wales Land and Environmental Court, which could provide good models here. However, as we've seen in other jurisdictions, an environmental court on its own will not address traditional barriers to access to justice. So, for example, lack of legal aid, high administrative costs or cost risk, and lack of awareness of the law and how it applies to a particular situation. If the government is to follow through on its commitment in the programme for government to set up a specialised environmental court, such a court should allow broad access to justice to include broad rules of standing. So remember, standing is the ability to take a case, and that should include things like class actions or actions on behalf of future generations, and it should also include a limitation on costs. It should also be accompanied by a public education and engagement programme. This is a really important cornerstone of an effective environmental court, particularly for marginalised groups. A programme of educational outreach would improve the court's visibility and credibility, helping people to understand its importance. However, an environmental division of the High Court is not likely to achieve this. The High Court is still bound by all the well-cited barriers to access to justice. And using the commercial court as a potential model, I mean, the commercial court is very expensive and it's designed to move commercial and high-value multinational type disputes through quickly. So that kind of a model would not be suitable for all types of environmental and planning disputes, which would allow broad access to justice. So finally, to conclude, access to justice is essential in the implementation of the Aarhus Convention. It is a really important tool in holding the government and other bodies accountable to their legal obligations and ensuring that the Dáil-declared climate and biodiversity emergency is treated with the urgency it requires, particularly in the context of successive failures of government. Thank you.
Thanks, Rose. That was great. So interesting. And thank you to everyone who's putting questions into the Q&A box. Keep them coming and we'll have some time to address those after Orla's presentation. I'll just invite Orla to take it away whenever you're ready.
Thanks very much, Clodagh, and thanks again to the Community Law Centre for the invitation to join you today and to speak about access to justice. So for my around about 20 minutes, I'm going to talk about the benefits of the access to justice provisions in the Convention by drawing out some lessons from case law. So, apologies. In terms of the three benefits, I'm going to focus my presentation on. I've picked three key benefits. We could pick far more, but for time constraints, I'm going to focus my attention on the following three. So the first is about broadening NGO standing in environmental cases. So a lot of these will pick up on themes that Rose has already started to discuss with you. The second is about widening the standard of review in environmental cases. So what does that mean? It means whether courts will look at environmental decisions and apply a closer scrutiny, or will they apply a very deferential, respectful approach to maybe other branches of government or public bodies like the planning board. So we're going to look at how that has been impacted. And finally, the third benefit I'm going to look at is this ban on prohibitively expensive legal costs. So In terms of that first benefit of broadening NGO standing, so this is something that Rose has already been talking about, so I won't spend too long on it, but just to recap, I suppose that this idea of standing is about the entitlement to take a legal challenge. As Rose mentioned, to be able to take a case, you need to come within the public concerned, and that means that you have to have either a sufficient interest or maintain an impairment of rights to invoke this review procedure. And I'll speak a little bit more about what that particular review procedure entails when I talk about the second benefit. But this really important overarching requirement is that the public concerned does have wide access to justice. And we see that coming up again and again in the case law. So as Rose also mentioned, NGOs that promote environmental protection and meet any requirements set out in national law should automatically have standing. And then we have that broader general right of access to justice for members of the public who meet certain criteria, if any, laid down in national law to challenge breaches of national law relating to the environment. So what kinds of things have been coming up in the case law? So I'm going to refer to, I suppose, findings and decisions of two important oversight and enforcement bodies. So the Aarhus Convention Compliance Committee, which Rose mentioned has an important role in overseeing the implementation of the convention and makes non-binding but very persuasive findings and recommendations to the parties. And then the European Court of Justice, which is charged with interpreting and ensuring the application of EU law, including EU environmental law. So what these bodies have had to say about standing. So firstly, the Irish Compliance Committee in relation to Article 9, in relation to Article 9.2 has said that standing rules, if they are to be imposed at all, need to be clearly defined. They shouldn't impose an excessive burden on environmental NGOs, and they shouldn't be applied in a manner that significantly restricts access to justice. And in relation to Article 9.3, the Compliance Committee has said that whatever discretion member states have in terms of setting up standing rules, they shouldn't be used as an excuse to introduce or maintain criteria so strict that it effectively bars NGOs, or almost bars all NGOs, from challenging breaches of environmental law. So access to a review procedure should always be the presumption rather than the exception. And then at the European level, in Dürgarten, the European Court of Justice in Luxembourg said that national standing rules, and in this case, these were national standing rules that only allowed NGOs with a certain number of members, here 2,000 members. So a rule like that required a very high membership number, that was incompatible with the access to justice obligations on member states in EU environmental law. And they emphasised that any condition that you want to impose in relation to standing should still deliver wide access to justice and ensure judicial remedies are effective. So what I wanted to do then is to sort of pick an example of a national case that standing rules have been invoked and used successfully to sort of advance an environmental cause. So a nice example of that is the Belgian climate case. So this climate case was modelled on the very famous Urgenda judgment, which some of you might have heard of. And so in this case, the Brussels Court of First Instance found that the Belgian governments had breached their duty of care and had breached human rights obligations by failing to implement sufficiently robust climate policies. Now, in the course of that case, the government had challenged whether the plaintiffs involved in that case, so an environmental NGO, Climate Act, and the citizens who had taken the case alongside the NGO had standing. And in the course of its judgment, the Brussels Court of First Instance found that Climate Act, the NGO, did have standing by virtue of its privileged status as an environmental NGO, and on that very basis was entitled to litigate to protect the environment under the Aarhus Convention. So specific example there of how the rights to broad standing could be invoked at the national level to take a really important case. So the next one I want to talk about is widening of standing, or the standard of review rather. So what do I mean by that? I mean the level of scrutiny that courts will apply in reviewing a decision of government or of another body like on board Orla. So for example, will the court allow a lot of discretion to these bodies? Will it closely scrutinise and maybe even start to think about the merits of the decision they've taken? So environmental cases generally will take the form of a judicial review, and judicial review traditionally has been concerned with the procedural legality of a decision. So have proper procedures been followed? And they're not really concerned with the substantive merits. So kind of reviewing again, were the merits behind the decision correct? So traditionally, it's only in very extreme cases, so the test is one based on irrationality or unreasonableness, that the court would interfere with the merits of a case. So the language used in Ireland is that the Kuhn decision would have to plainly and unambiguously fly in the face of fundamental reason and common sense. So only if the decision was completely disconnected from reality, if you like, would the courts be interfering. And so the Irish Convention has a very significant role here, because under Article 9.2, there's a requirement that the public concerned should have access to a review procedure, which allows for both a review of the substantive and procedural legality. So not just procedural questions, but also potentially substantive review. So what does that mean in practice? Well, the Aarhus Convention Compliance Committee, which we've referred to already, has found in one of its recommendations that this test, the unreasonable test, may not meet the standards of review required by the convention in relation to substantive legality. So it wasn't convinced, it didn't make a finding of non-compliance, but that was only because it didn't have sufficient evidence before it. It's expressed a preference for a test called a proportionality test, which would look at whether you're pursuing a legitimate aim and whether you're going further than that legitimate aim. And if we were to introduce a standard like this, it would potentially lead to subjects or to decisions being subjected to much more rigorous judicial scrutiny. And I think it's important to note that this is an area that is very much still under consideration, and there is a complaint before the Irish Compliance Committee again on this matter. So it's definitely an area to watch. So a nice example of kind of a victory in that space, I suppose, or an example of it being an environmental cause benefiting from these reviews is the case that Rose mentioned earlier, Friends of the Irish Environment and Government of Ireland. So as many will be aware, that case, the Supreme Court quashed the National Mitigation Plan, so Ireland's first attempt at a sort of framework response to tackling climate change, on the basis that it was not specific enough in detail. It didn't show how the government was intending to meet its 2050 target. So what was really interesting in that judgment was that the Supreme Court started to actually look at the merits of the National Mitigation Plan. So, for example, it characterised the agriculture chapter of that plan as being excessively vague and aspirational, and it specifically stated that it was quashing the National Mitigation Plan on grounds which were substantive rather than purely procedural. So again, we can see that important influence of the Aarhus Convention there, the echoing of the words of Article 9.2. And I suppose it's there's a question there: is it signalling a willingness on the part of the judiciary to start to move towards a more substantive form of environmental judicial review, where the courts will more closely scrutinise a decision? So the last one I want to talk about is the banning of prohibitive legal expense. So that, as Rose mentioned, is provided for under Article 9.4. And as Rose mentioned earlier, it's implemented via the special cost rules. So generally speaking, we disapply the standard rules of costs follow the event, and under the special cost rules, each side will bear their own costs, and there'll be an opportunity for both for the applicant, so the NGO or the individual, to recover some costs potentially. So sadly, this has been an area fraught with a lot of confusion around what would come under these special cost rules. And as a result, there's been a lot of litigation in this space. And we could probably spend all morning talking about the various cases, but I won't subject you to that. But instead, I will just focus on sort of one case or two cases rather, that kind of show how these rules have had a really important benefit. So the first thing I want to mention is a judgment of the European Court of Justice in Edwards, where it said that in assessing whether costs are prohibitively expensive, we need to consider both the subjective and objective elements. So costs should neither exceed the financial resources of the person who is taking the case, so that's subjective element, but also they mustn't be objectively unreasonable. So a nice recent example of sort of how these cost rules have played out in practice was a judgment of the Irish Supreme Court in Clone and Bord Pleanála. So here the issue was what role the not prohibitively expensive criteria would play in assessing costs that were to be paid to Bord Pleanála where they successfully defended a case. So here the Supreme Court cited the Edwards judgment that any assessment of not prohibitively expensive would have to have a subjective and an objective element, and that in this instance account had to be paid to the costs that Mr. Clone had paid to his own lawyers, which were about €32,000. So the court characterised that as being a significant personal burden. And as a result, that any costs being assessed against Mr. Clone to be paid to Bord Pleanála, and so that they would ensure that costs were not deemed to be prohibitively expensive, had to be a very modest sum, as any other approach would fail to take into account Mr. Clone's personal circumstances. So ultimately, the court determined that €1,250 was the appropriate amount of costs that should be awarded against Mr. Clone. And I think what's really striking about that is that it's a big difference between what Bord Pleanála had actually spent in costs in defending the proceedings. So what they had initially spent was about 86,000, whereas the costs awarded to satisfy the not prohibitively expensive criteria were just over €1,000. So I think we really see the dramatic impact there of what the not prohibitively expensive cost rule can achieve. And there's an excellent discussion of that in Anya Ryle's article, Environmental Law Enforcement, Emerging Challenges in the Irish Planning and Environmental Law Journal. So if you want to go and look at that more closely, you can. So I think it's important to emphasise, and it picks up on a theme that Rose mentioned, Ireland has been particularly poor in this space in terms of ensuring that costs are not prohibitively expensive, and that has been highlighted again by the European Commission in its environmental implementation report, where the Commission has stated that it remains concerned about the very high cost of environmental litigation in Ireland and the lack of certainty at the outset about what costs environmental litigants are likely to face at the outset. So it's a big issue in terms of Ireland actually complying with that at a more structural level. So just to maybe wrap up and emphasize why all of this is so important. So both in terms of the right itself, but also the implementation. So Article 1 of the Convention sets out that the various pillars of the Convention, so access to environmental information, public participation and access to justice, they are not ends in themselves, but are simply a means of contributing to the protection of the right of every person of both present and future generations to live in an environment adequate to his or her health and well-being. So I suppose to the extent we want to promote a substantive right to a healthy environment, these are critical tools to both ensuring that such a right is supported and enforced. So the importance of getting this right can't be overstated. So with that, I'll finish up. Thanks for listening, and I'm happy to answer any questions.
Thanks so much, Orla. That was excellent. We have a lot of questions coming in. Just to mention that some of these questions are quite specific to people's or community circumstances and situations, and we can't provide, I suppose, what might be qualified as legal advice in a webinar. But if you have a query that you think you might benefit by coming to our free legal advice clinic, you're more than welcome to get in touch. So if you email info@communitylawandmediation.ie, we can schedule you into a session in our free legal advice clinic. Our next one will be on the 16th of November. I'll put that in the chat box as well. One question that has come in is, how can access to justice be made more inclusive and widely available? I'll put that to either of you, Rose or Orla, if you have any thoughts.
I'll jump in first. I suppose, like, we know from various reports that barriers to access to justice certainly include cost. So, like, to help with that, if environmental cases were covered by the Civil Legal Aid Scheme, that would absolutely help. And not only if they were covered, but if the Civil Legal Aid Scheme advertised their services to make people aware that they could approach them for legal assistance if necessary, that would help. And just to say on that front, there is a review of the Civil Legal Aid Scheme underway for the first time in 40 odd years. So that's just something for people to bear in mind if there is maybe a public consultation process, or to make your views heard on that. But there are other barriers to access to justice, and often it can do with people not understanding the law, or not knowing how the law is relevant to their situation, or not knowing that they can actually mount a legal challenge in relation to the particular situation they find themselves in. So, you know, engaging communities, having a public engagement in the public education program, I would see as really critical to overcoming some of the barriers to access to justice.
That's great. Thanks. Orla, do you want to come in on that one, or I can move on to the next question?
I think you can move on, Clodagh.
Perfect. Another question is, the process of decision-making by planning departments appears to be very poorly open to public observation. Can the Irish Convention offer this situation to be made more open and transparent? So I suppose, just speaking kind of more broadly in relation to environmental decision-making within public bodies, do you think that Aarhus can make that more effective than it is at the moment?
Well, I suppose planning decisions generally, you know, allow for public participation. So, you know, you can make observations as part of the planning process, and you can seek to review planning decisions, either depending on the type of decision, whether it's directly to An Bord Pleanála or directly to the High Court through judicial review. And there are kind of wide-standing provisions as to who can make those observations and who can take those claims. And it's much easier to do that, I should say, even though there are barriers in environmental cases, it's much easier to make these kind of cases than in other areas of law. But certainly, you know, events of the last number of weeks have shown that, you know, some of our planning bodies and An Bord Pleanála, like some of their decision-making processes and oversight procedure, like, should be called into question. And so it really highlights, I think, the importance of oversight of planning decisions and being able to access justice in relation to planning decisions.
Orla?
Yeah, I think I agree with everything Rose is saying there. And I think additionally that I think we could go a lot further in terms of making these things inclusive in very practical ways, like the time frame you can do it, resources being available and encouraged. I think sometimes there's a perception that maybe your knowledge is not valid, and it often is really, really invaluable local knowledge that members of the community and local groups have to share. So I think we could go a lot further in sort of advertising you know, that knowledge is really valued and really important, because I think oftentimes when, you know, planning or a planning application is live, or when there's, you know, consultation on a particular government program, people don't feel like they have something valuable to contribute, and they're not encouraged enough. So I think we could go a lot further in that way, and that would be very much supported by the overarching value the Aarhus Convention places on public participation.
Thanks so much. A question has come in on public participation and residence groups. So if someone is a member of a residence group, do they have to have official standing, or do they have to be registered somewhere or somehow to have standing?
Without giving legal advice on any particular issue, in environmental case, certain types of environmental cases which invoke the public participation directives, residence groups do have standing to take cases, and we've often seen cases of residence groups, you know, judicially reviewing planning decisions or developments in their local area. So it just depends on the type of action. So if you are considering challenging a decision, just maybe get legal advice on whether it's sufficient that you stay as a residence association, or whether you need to look at incorporating. But normally residence associations in these type of environmental cases do have standing.
Go ahead.
In terms of like, it's more of a kind of future looking thing, but it may be something nevertheless for groups on the call to be aware of. In terms of any changes to the planning laws, one thing that was, I suppose, being proposed previously was a minimum length of being in existence. And so that's something that we should all be very conscious of, I think, in terms of being able to both participate and access justice, that any reforms to the planning system shouldn't, I suppose, limit or put those constraints on community groups that they would have to be in existence for a particular period of time, because they are serving obviously a very important purpose oftentimes in environmental protection. So those kind of time limits, you know, just to be aware that those potential reforms could be coming down the tracks, and we should be kind of conscious to, I think, raise our voice about, you know, opposing those.
Absolutely, yeah. Thanks, Orla. That's a really timely discussion. Another question that's come in is, do you think Ireland is likely to meet its climate targets if access to justice is restricted?
Well, we're not meeting our climate targets, and we haven't been meeting our climate targets, and we have been really poor generally in relation to our environmental and climate obligations. I mean, we're the third worst per capita in Europe. So we have shown this failure to adhere to what's set out in law. And so I think access to justice and environmental democracy and oversight and accountability are really, really critical tools in holding the government and other bodies to account. So I absolutely think it plays a really important role, and whether we'll achieve them without it, well, we're not achieving them right now.
Absolutely. Orla, do you want to comment on that?
Yeah, I'd agree with what Rose is saying there. And I think, you know, up to now, climate cases have served a really important function in sort of propelling action, you know, after a government has been found to maybe fall short of their legal obligations. There's a requirement immediately, it puts it on the political agenda, so politicians have to start to take a view on climate, but also, you know, kind of concrete measures that follow. So I think it's kind of widely seen that many of the governance structures that followed in Ireland after Climate Case Ireland could be in some way traced to how that judgment sort of started to put climate change on the agenda. So I think any restrictions on access to justice would be detrimental really to achieving our climate targets.
Absolutely. The next question is, should judges hearing environmental law cases have special expertise in that area?
Well, I hop in first. I think there can be benefits, obviously, to judges, you know, being appraised of a particular area, but I don't think it's essential. I often think that, you know, judges having general expertise and coming at, I suppose, a matter like they will be able to come up to speed very quickly, and there's benefits to that too. But I do think maybe kind of judicial education around environmental issues would certainly be beneficial. But I am a small bit uncertain about this idea, like Rose had said, about a sort of a separate environmental list with maybe one or two judges working on that. But I don't know, maybe Rose, you have different views.
I certainly would pick up on your point for kind of general education for our legal community, our lawyers and our judges, on just how serious the climate emergency is. Because I mean, obviously we all read the papers, we all have a general appreciation of it, but I think actually to understand the science and the policy making and what is happening and our role in what's happening around the world and our obligation, our moral obligation. I think a kind of a general education is really important, not just for judges, but also for lawyers who perhaps are representing fossil fuel companies or other such companies who are really responsible for the situation that we're in. But there are pros and cons to having, you know, this kind of dedicated court where you have kind of an expert panel of judges. Like I would be concerned, there are you know, models of environmental courts around the world that we can draw upon, but they don't necessarily address barriers to access to justice. And if the court that's being proposed is done along the commercial court model, I would be worried that actually would make access to the courts a little bit more difficult. And if it fast-tracked planning applications and planning reviews, like already there's an 8-week limit on a planning judicial review, which is really tight. The normal JR time limit is 3 to 6 months, depending on what it is, whereas it's 8 weeks in planning, which is really tight. That's 8 weeks to have your application in court. So by the time you've instructed a lawyer, maybe got your information under the AIE, analysed your case, prepared your, instructed a barrister, all of that, it's a really, really tight turnaround time. So if they're going to kind of introduce a more fast-track procedure, that's going to really ensure that any applicant will certainly need a legal team. And like, so dependent on lawyers acting on a no-win, no-fee basis, particularly in the absence of legal aid.
Thanks both. I'll just move on to the next question, which is around resourcing. And if you were wanting to take a legal challenge, for example, against a private actor, this person says there is a huge gap in the type of expertise companies can provide or that companies might have access to, as opposed to what a common citizen might be able to bring to court. And the perception that regulations and laws are designed around the interests of private companies. Do you have thoughts on this or on how the perception of access to justice can generally be improved?
Yeah, it's really difficult. It's a real uphill challenge, I think, for individuals and residents groups and community groups, for example, if they're up against, you know, a big corporate entity or the state. It is a bit of a David and Goliath situation, and I do think like it does call in. I suppose it points to the need for the education that we just spoke about for the legal community to be broadened out, I think, actually, for all professionals. Like we have in CLM, we take all types of cases outside of environmental cases, and we often get, you know, medical professions or engineers or other experts to provide their own services on a pro bono basis. So we can get, you know, expert reports or expert assistance on a pro bono basis. And I think on climate and environmental issues, if there was that broader education on the real imminent threat that we are all facing, that might help with that. But I do acknowledge that it is an uphill struggle for communities and groups who are trying to take cases, because, you know, even if you get your lawyers to agree to act on a no-win, no-fee basis, you might often have to incur costs in terms of professional reports.
Great, thanks, Rose. Did you want to fill in that one, Orla?
Yeah, I mean, I agree with a lot of what Rose is saying there. Like in theory, there are certain elements of the law that can still be useful in that sort of, well, what I'm understanding is sort of a private actor sphere, but there are like as we've talked about already, there's the cost risks that really just make this kind of very difficult for communities or for individuals to realize. So I think a kind of absent tackling some of that and the recognition of the sort of inequality of arms that exists there, it is really just very difficult for members of the community to try to look at those kinds of options.
Absolutely, yeah. Another person has a question on what happens in other countries. So they say that I have the impression that major projects are advanced much more quickly in other countries. For example, high-speed rail projects in France and Spain. How are such projects not delayed by environmental objections, or are legal procedures just quicker in those countries?
I'm not sure if I can comment too much on that, to be honest, but I will say, and I mentioned in my presentation, there is a bit of a false narrative about the role of judicial review and how it's holding up. It's being pitted against kind of the housing crisis, and it's holding up, you know, us and government dealing with the housing crisis. I mean, if you pare it back and look at the numbers, for example, there has been an increase in judicial review. Like, so in 2012, I think there was 17 kind of planning judicial reviews taken, and that increased to about 80 in 2020. But that was 80 in relation to about 2,700 decisions of Amblor Planola. So less than 3% of those decisions are being challenged. And the vast majority of those cases were successful. So to be successful, it means that there was some error in process or substance of the decision of Amblor Planola. So it should have been challenged because it was successful. So there is this kind of narrative that you know, planning is making life difficult for the government and developers to deal with the housing crisis, and it's in fact responsible for the housing crisis. And I would really challenge that. And I would also point to the fact that there's a really substantial amount of planning permissions by developers that are never activated. And that's not really talked about very much. And I'm not entirely sure what the reason is. And perhaps it's to increase value of the land and never do anything with it. But like what is being stated in the media and by our politicians and by our government, even in the face of controversy on Bord Pleanála, is that we need to stop this growing industry of legal challenge, because it's you know, holding up, it's increasing and making it more difficult in relation to planning for our developers and for the government.
Great, thanks, Rose. Do you want to comment on that one, Orla?
Yeah, I would agree with what Rose is saying there in terms of it's oftentimes a kind of a misdirection of anger and it's, you know, that not maybe valid often because of how oftentimes when these challenges are taken about a planning decision, they are have, you know, such a large proportion of them have been successful. But also, just for me, it really clashes with what we know about the climate and biodiversity crisis. You know, when individuals are going to the trouble of maybe, you know, invoking, for example, the EU nature laws or something, they're actually doing us a public service oftentimes to protect a public good. And so I think it's really important to maybe to kind of understand this in the wider context as well. But I would definitely agree with what Rose has to say on that point.
Great, thanks both. And then the last question that I think we can address today is, how can a lack of public awareness of access to justice be overcome?
Well, I think events like today probably help. I do think there's a, you know, just a need for a public education program, really. I personally hate the name, the Aarhus Convention and Aarhus Centres, because I just think nobody knows. It's just a random, you know, town in Europe. Nobody really knows what the Aarhus Convention means, and I don't think it's a very self-explanatory title. I think it's an unfortunate title for it. So I think today, like events like today, really help to explain the rights that people have, so that people kind of use those rights. But we need more of them. Like we can see, you know, this is just one event, and we'll make it available, and we'll make sure to circulate it. And please do the same for anyone watching today. If you think it would be helpful for other people in your community, please do. It's going to be available online. But we need it, like, to roll out a kind of a nationwide, like, public education engagement program around it. And we need to make information available to communities. So, like, you would have seen with the first pillar and even the second pillar too, on the rights of access to information and the rights to public participation. If people want to get further information on that and how to make an access to environmental information request, for example, you know, it'd be good to have an Aarhus type centre available for people to get that kind of information. I mean, CLM does that work. So please do come to our clinics if you have those kind of questions, but we are just one service, and we do need maybe a more comprehensive provision in relation to that.
Absolutely. Orla, do you want to comment on that one?
Yeah, so I suppose in addition to sort of the, you know, public information campaigns that can be run by organizations like CLM. Also, I think an important feature is the media, and the media, I suppose, presenting a picture that is not just, you know, planning is getting in the way of, you know, housing development, that we have a sort of a broader debate that is capturing the themes we've discussed today, like the essential role access to justice has to play in ensuring that we are able to tackle the climate and biodiversity crisis, and how really that narrative of kind of planning and judicial review getting in the way of another really important crisis, that is sort of countered and engaged with kind of meaningfully, so that we do, I suppose, have this more nuanced understanding of these issues. So I think that would be really important to see as well.
Thanks so much, Orla. So we're going to wrap up today's session, everyone. We'd like to thank the Community Foundation for Ireland again for funding this series, to our speakers today for their really wonderful and comprehensive contributions, and to the audience for attending and for your really engaged Q&A. It was really fantastic to see such high engagement. This recording will be available on our website. The recording and the slides will also be sent around to everyone who registered for this and to our previous sessions as well. So that'll be sent out this week. As Rose mentioned, please do share this with your networks. Feel free to share it with community groups that you're a part of. And if you have a query that you feel will benefit from free legal advice, you can book into our clinic by contacting info@communitylawandmediation.ie. Okay, thanks everyone.